Yeah?
Yeah, thank you.
Okay, let's look at this flow chart, which I held up at the White House when I was speaking about why it's so important to have lawyers. Our case is starting at EOIR, the Immigration Court. That's the orange circle. We're going to have the case continued, as your colleague just asked me a minute ago. In this special immigrant juvenile status, we're asking the court to continue it while we go to the family court in our state. And again, every state has a different name for this court. The federal statute calls it the juvenile court. Here in New York, it's largely called the family court. At the family court, we're seeking these special immigrant juvenile status findings. And we're doing that as part of a jurisdictionally appropriate proceeding in the family court. I'm going to talk about that more in a minute. If we're successful and we get the findings from the family court and get that child protection and stability and planning order, we're now moving over to the SIJS. That's the benefit side of immigration in DHS, where we file a visa petition. When we have the receipt from the visa petition, we might move to the court for another long adjournment, continuance, or termination, but ICE is now taking the position they will not terminate the removal case until the visa petition is approved. By statute, the agency has 6 months to approve that petition. Then the court will terminate the removal proceeding, moving jurisdiction back to the green circle at the bottom, back to USCIS for something called an adjustment of status interview. All of these things have forms and paperwork and procedure and regulations, and we have manuals to guide you through every step of the way. But the happy ending is the child gets a green card at the end. If the child receives asylum, they become an asylee, and 1 year later, they can do this same adjustment of status step. If a child secures special immigrant juvenile status, they go right to the adjustment of status process after they've secured the predicate family court orders. Well, we introduced Hector and Eduardo already. Look at my crazy flow chart. I don't expect you to read it. I know it's printed out in front of you. I did this because lawyers continuously ask me, how many hours shall I anticipate? What are the stages of a guardianship case in New York Family Court? This flow chart might fit a typical scenario in New York. There might be a very different procedure in North Carolina or in Florida. In fact, I lectured in North Carolina and did a lot of research there about North Carolinian law, and they don't even call it a guardianship, they call it a third-party custody. So depending on where the child is residing, we're going to need specifics of your family court jurisdiction. This is not a flow chart that's meant for you to memorize. It's meant for you to be helpful to understand that there's going to be interviewing with the client, interviewing with the potential guardian or the custodian, filing the appropriate paperwork in the New York Family Court, and this raises the issue of dual representation. Many areas of immigration law you can have dual or multiple representation. For example, we used Joe's U visa example earlier. He represented the mom and the 4 children. No conflict of interest, no problem whatsoever. In a typical immigration marriage case, you have the U.S. citizen spouse or the permanent resident spouse and the spouse seeking benefits. Dual representation perfectly authorized by regulation and ethical opinion. In family court or juvenile court, you may not represent more than one party. We take the position we represent the children. So in some of the state court systems, there will be a panel attorney or a paid-for state attorney appointed for the child as well. In others, they will accept you as pro bono counsel solely. Sadly, some of the family court judges don't want you to be the lawyer for the child because they have a paid position for their family lawyers for that. They don't have any paid money for the mom or dad or uncle Ronaldo who wants to get a guardianship. So they'll pressure you to switch and say, you don't need to represent the child, you can represent the uncle. These advanced strategic decisions are things that will help you through. Don't worry about it for now. I just wanted to acknowledge that often in these cases, the adult is pro se. And there is some ethical guidance in the state of New York that in indigent law such as this, it is appropriate for a lawyer to assist a pro se applicant. Also, because you have a unity of interest here, both you and the uncle want to get the guardianship. There's no obvious or immediate or apparent conflict. But you may not walk into family court and represent both parties. Okay, what is this special immigrant juvenile status? Congress passed this law in 1990. It was initiated by the congressional delegation in California that was having children in long-term foster care, and then they were becoming homeless and undocumented at the end of many years in care. So the state of California and other states across the nation petitioned Congress to create a category for children who have been abused, neglected, or abandoned, or some other legal term of art in your state. They say other similar basis under state law, to give them a path to permanent residence so they don't go from being child who's in a foster care or guardianship placement or custody situation, and then at turning 21 they become undocumented. In 1990, the law required both parents to have abandoned, neglected, or abused you. That was changed in 2008. If you are doing research in this area, any materials, manuals, trainings, regulations even that are currently on the books, case law, prior to 2009 is out of date. Do not get confused. Sadly, some of our family court judges went to a training back in 1992 and they're still using it, and the law has changed. Today, to be eligible for SIJS, you have to be physically present in the United States. This SIJS, that's the nickname for Special Immigrant Juvenile Status. You can't be outside the country when you apply for this. You must be under the age of 21 at the time the visa petition, that was that green circle going to the US SIJS on the overview flowchart. Very critical deadline. You can complete the case after the child turns 21 in some of the bureaucratic adjustment of status processing, but your family court proceeding must be complete and the petition filed with immigration before the clock strikes on their 21st birthday. Oops, you have to be unmarried, and we made that text jump because, oh my God, it's a huge paragraph. Here we go, we're gonna break it down. The child is declared dependent on a juvenile court. So in New York, it's generally family court, it could be surrogate's court. Declared dependent, in my mind, really means the family court has accepted jurisdiction to make a custodial decision about this child. Who should be the custodian, the guardian, where should the child be placed? So in New York, there's case law that a child in juvenile delinquency, where there was a potential of being placed in a detention center, that's a custodial determination, and a SIJ order could be made in that matter as well. There's one case in New York where the only thing at issue was child support, and the court said that's not a decision about the care or placement of the child, so the child was not declared dependent on the court. We guide you through this again. The final finding the court must make is that it's not in the best interest of the child due to this neglect, abuse, or abandonment of the child to be returned to the country of origin. And that is not done with a whole asylum-like evidentiary proceeding of how terrible it is in El Salvador, what it's like in this particular town. Instead, it's more of the family court tradition. Where is this child better off? And in our hypothetical, the number one with Eduardo, where he was living with a family that threw him against the wall, a mother who called him a good-for-nothing. These are standards under New York law that are clearly the physical violence, hitting someone with anything other than your hand, anything that leaves marks, that's called abuse, or at least it meets the standard of neglect. The mother's inaction would meet the standard of neglect, and the fact that he has both parents that have abused him and neglected him in this way, and the early death of his other father could be a similar basis under state law, would help Eduardo qualify if his uncle sought guardianship over him. Common question people ask us, can Eduardo's uncle Reynaldo be a guardian when he's undocumented? Yes. If our family courts in the United States started taking immigration status into consideration in the cases, a large number of cases would be at stalemate. Even undocumented people in New York are ordered to go work and pay child support, even though they're technically not authorized to work in the United States.